As much as we don't want it to, injury and illness in the workplace can and does happen. Today, I want to dig into some frequently asked questions about workers' compensation in the state of Illinois. To help me answer those questions, I'm joined once again by Marc Shuman of Shuman Legal, a leading personal injury law firm based in the heart of Chicago that opened its doors in 1996 and has successfully represented more than 25,000 people. Marc, thank you for joining me again.
Nice to see you, Michelle. Always a pleasure.
First and foremost, shed some light on how it all works in the state. Is workers' compensation required in Illinois?
For employees, yes. By statute, an employer has to have workers' compensation coverage for any employees. There are some exceptions that would not be covered. So for example, if you are an independent contractor, if you are a volunteer, the only other things that wouldn't be covered if you're a federal postal worker or a railroad worker or a longshoreman, those are not covered by the Illinois Workers' Compensation Act. However, so if you're a postal employee, for example, if you lift up a mail bag and you hurt your back, that's federal workers' comp. They have their own internal system that is not covered by the state. But we've had many federal employees, a postal worker, let's say, is delivering mail and gets rear-ended in a car accident. We can handle the personal injury case against the person who caused the car accident, and then the workers' compensation would go through the federal workers' compensation system. We had a postal worker who fell through a stairs. And so if there's a companion personal injury case, we can handle the personal injury aspect, but the workers' comp goes through the system. Also, there's a quirk if the Chicago police are not covered by Illinois workers' comp because the statute says that any municipality where there's more than 500,000 people, the police are not covered. So they have their own system as well. We've had many suburban cops that have workers' comp that we can handle. The smaller suburbs are covered by the Illinois workers' compensation system, but Chicago police have their own system. But again, if it's a rear-end car accident with the Chicago police, same deal, we would be able to handle the personal injury end.
Walk me through what kinds of accidents are covered by workers' compensation in Illinois.
First of all, any specific injuries of blunt trauma. For example, if someone trips and falls over a box at work or a wet floor or lifting something and hurts their back, that's a specific injury that's covered. Also, repetitive trauma injuries are covered. If a person is a machine operator pushing and pulling hundreds of times a day and over the course of weeks or months, they develop pain in their wrists like a carpal tunnel injury or their elbow, which is cubital tunnel, that's a repetitive trauma, is also covered. If you aggravate a pre-existing condition by work activity, that's covered as well. And lastly, if you get an occupational disease, if some kind of smoke inhalation or some chemical causes you to become ill, that's also covered under the Workers' Compensation Act.
There's more on that list than I thought. Let's talk about the process around this then. What do I need to do to receive workers' compensation if I was in an accident?
Good question. So the most important thing is you need to report the injury. And under the statute, you have to report it within 45 days. And it can't be to a coworker. You have to tell a supervisor. Many employers require you to fill out a written report. Some, it's not a requirement. So if you tell them orally and they accept it, that's fine, but it has to be done within 45 days. In addition, I would always recommend to get medical treatment right away. And when you go to the hospital or doctor or outpatient center, make sure to tell them that you got injured on the job and how you were injured. If you make the mistake, and we've had this before, someone just go to the hospital and say, I woke up with back pain this morning, and you do not state that you were lifting a box and had back pain, it could happen. The employer could actually say, you didn't say you got hurt at work, we're denying your claim. So it's important that you let them know how you got hurt and that you got hurt at work. And lastly, if a doctor keeps you off of work because of your injuries, you need to get a note from the doctor, call it an off work slip or a disability slip, it's called, to say that you can't work, and you need to give that to your employer. Sometimes a doctor will put you on light duty restrictions, no lifting above 10 pounds or no bending or stooping, whatever it is. And you need to also give the light duty slip to the employer so that they can attempt to accommodate you. So that's basically how you get things started.
And having said that, when should I hire a workers' compensation lawyer?
I would say immediately, and here's why. The good news, the way the system is set up by statute, you don't pay anything up front. In fact, and all attorneys have the same fee. The difference you get between one attorney versus another attorney is their knowledge, customer service, expertise, things like that. But everyone's the same fee. You don't pay anything until the end of the case. And if we are not successful, you don't pay anything at all. You also don't pay hourly, and there's no upfront cost. So it's very much in your benefit to hire someone right away and have someone start helping you make sure that things are documented properly and you're getting the proper treatment you need and that you're getting your benefits if you're off of work. There's no point in waiting because you're going to pay the same fee if you hire me on day one or hire me the day before it's going to settle. The fee is based on the recovery. So I'd much rather have it earlier on and make sure things don't go wrong than have to undo a problem case from the start and then try to get it, because that could cause delays in getting money or getting the proper treatment, et cetera. So I would recommend the sooner the better, immediately.
Well, I think it's safe to say that having to make a claim in the first place is stressful. And then there's the added stress of being hit with additional bills. Let's talk about compensation. How much of my salary will workers' compensation cover?
So by statute, what they do with everybody is they calculate what they call your average weekly wage. And what that means is they look to the 1 year from the date of your injury. So if you are hurt on January 1st of 2020, they look to your wages from January 1st of 2019 through January 1st of 2020, and they take an average over the entire year. Now it's your gross wages, excluding overtime and bonus. And then once they calculate that average over the course of the year, it's not how much you're making on the day you're hurt, it's the average over the whole year. Once they calculate that average, that stays with you for the life of your case. Whether your case takes 2 months or 10 years, it doesn't fluctuate. The only exception to that is if you are a mandatory overtime worker. So some employers have to work a mandatory 50 hours a week. Then it's calculated at the straight rate for 50 hours, even though you got time and a half for the extra 10 hours. So if someone is making $15 an hour and working 50 hours a week, it's calculated 15 times 50. So that's the only time that overtime would be included as part of your average weekly wage. And then the only other exception is if you have 2 jobs and the employer knows about both jobs, they will actually combine both wages and to get your correct average weekly wage. So someone who has a second part-time job, as long as the employer was aware of it and you have to be off of work for both, then both of those wages are included as part of your average weekly wage.
Does workers' compensation help with my other expenses after an accident?
The statute says you get all of your medical bills paid 100% with no co-payments, no deductibles. Number 2, you get what's called temporary total disability, TTD, or your workers' comp checks, as people like to call it. And that is 2/3 of your average weekly wage. So for example, if someone makes $600 a week gross before taxes are taken out, excluding overtime, then you would get $400 a week tax-free as your workers' comp checks or temporary total disability checks. Then if someone goes back to work, let's say they're in the life of the case and the doctor says you can only go back to work 20 hours a week, then you can get what's called temporary partial disability, TPD, and that's 2/3 of the difference. Again, you get your regular 20 hours and then 2/3 of the difference between what you were making and what you are making. And then as far as settlement wise, if someone can never go back to work again, there's what's called permanent total disability benefits, which is you would get your workers' comp checks the rest of your life. That's the worst thing that could happen if you cannot return to work in any capacity. There's ways we settle that in a lump sum based on your life expectancy, but basically that's what you're entitled to. And then last, if let's say you have to have a job change because you cannot go back to work in the same capacity, then you're entitled to get vocational rehabilitation, where vocational training, where they will train you. They'll pay for training for another type of a job. And you can get what's called maintenance, which is your workers' comp checks while you are looking for a job. They continue paying you until you get a job. And then unfortunately, if you get a job paying you substantially less, then we get into a wage differential situation in terms of a settlement where they look at the difference between what you were making and what you are making. But that's basically all the different ways you get paid.
I want to go back to temporary total disability. You mentioned that. How long do I have to be off work for workers' compensation to receive temporary total disability benefits?
So it's kind of a funky rule, actually. If you're off 3 days or less, you don't get that benefit. So the employer has to pay you on sick days or whatever, or you just don't get it. If you are off more than 3 days, but less than 2 weeks, then they start paying you from the 4th day. And if you're off more than 2 weeks, they start paying you from the 1st day. It's just rules-based. There's no, you kind of get punished for the short-term injuries, but that's how it goes with everybody. If you're off more than 2 weeks, then you start getting it from day one.
Well, that's really good to know. Now, I normally don't like ending on a worst case scenario, but I'm hoping you can spin it. My workers' compensation claim was denied. What can I do?
Well, definitely talk to an attorney right away. And we try to find out what is the basis of the denial. Are they saying you weren't hurt at work? Are they saying the injuries you have weren't caused by the work activity? It was either whether it was pre-existing and it's the same condition that it was, or that the alleged injury didn't arise out of and in the course of your employment. There's a lot of ways that they could try to say that it's not related. And we have to find out if what they're saying is not true and possibly do what's called an emergency hearing. So for example, if you are hurt in the course and scope of your job, you are entitled to all the benefits we discussed. If whether it's your fault, the employer's fault, or nobody's fault. So for example, I tell people if you slip and fall on a wet floor and the employer forgot to put the wet floor sign out, you're entitled to your full benefits. But let's say they put the wet floor sign out and you still slipped on it. You're still entitled to the exact same thing in both scenarios. Or let's say it's nobody's fault. Let's say you just bend over to pick up a box and you herniate a disc in your back. All three of those situations, you get all of your workers' comp benefits, your medical, your weekly checks, and a settlement based on how well you recover. So you don't have to prove. The good part of workers' comp is you don't have to prove fault. But the trade-off is when they made these workers' comp laws is you have to get paid according to these schedules based on how much money you make per week, your average weekly wage, based on the body part, and based on how well you recover. It's not a pain and suffering like it is in a personal injury case. It's what the settlement, when you get ultimately, is called permanent partial disability, which really means to what extent is the injured body part permanently and partially disabled. And it's a legal conclusion based on the thousands of cases before yours with someone with a similar injury. So there's good and bad about the workers' comp. The good news is, which I tell my clients, is most people could not prove negligence on the part of the employer. If you're bending over and you pick up a box and you hurt your back, that's nobody's fault, but you still get your benefit. So a lot of times that's better for you. You don't have to prove fault. But there are certain types of injuries to answer your question why they would deny it. Let's say you just trip over your own feet walking down the hallway. There was nothing about the job that happened. It's just, one of those crazy things that would not be a compensable injury. And there's other situations where it may or may not be. If you leave work and you trip and fall on an icy sidewalk that's outside the employer's premises, it's not most likely not work related. But if you fall in an employee-owned parking lot, it could be work related. So there's all kinds of crazy rules. And then in terms of, lastly, aggravation of pre-existing condition, certainly we would make sure that, if the doctor says it's related or aggravated or can tie up the aggravation or causation, then obviously we're going to fight and we're going to bring an emergency hearing or ultimately go to trial if we have to. So bottom line is you should really talk to an experienced workers' compensation attorney so they can get to the root of why they're denying the case and hopefully fight for you.
Marc, this insight on workers' compensation in the state of Illinois has been extremely helpful, as always. Thank you for taking time to answer some of the most frequently asked questions.
Glad I could be help. And obviously, if anyone ever has a question, they can always call. It's always a free consultation, no obligation. You can call, pick our brains for free. If we can help you, great. If not, it doesn't cost anything.
Fantastic. Thank you.